Welcome everyone. I'm Vincent Manancourt. I'm a journalist at Politico, and I have the honor of interviewing Wojchiech Wiewiórowski, the new European Data Protection Supervisor. Wojciech, you've been in the job now for a few months, although you were second in command under the late Giovanni Buttarelli. I've always thought of the EDPS as a curious beast in that its moral authority and perhaps its position as a global thought leader on all things privacy outstrips its perhaps limited role as a data protection authority for the European institutions. Wojciech, firstly, what do you think of that characterization of your office?
Well, that is definitely data protection authority, surprisingly similar to the data protection authorities in the countries. I remember when I first came to the office of EDPS in 2014, that was surprising for me how the structure, even the internal structure of the office, is similar to the one that I had in the National Data Protection Authority. Of course, the supervision looks different. Supervision looks different because there are less authorities that you do it with, less entities, and there are different kind of complaints, but they are different than the ones in the National Data Protection Authority. And at the same time, the work in the policy consultation field, so where you have to advise the legislators, is nearly the same as it was on the national level. And of course, the global discussion, the participation in the global discussion is much broader. So there are differences and similarities. There are also differences and similarities towards the other controlling bodies in the EU. Well, I'm there already for 5 years, so I may say that what I met when I started to be the supervisor did not surprise me too much, because it was actually the same what I had in the mandate as the deputy data protection supervisor. But I think with Giovanni, I had this opportunity to get inside this job and to find the similarities and differences. He had also long experience in the national authority, so we could somehow compare that.
So, you know, it's been a few months now. What have you been up to?
Apart from the continuation of the things that we did, we decided after the sad events that happened in August, we decided that by the end of the mandate, we will continue everything as it was planned 5 years before, and also then at the beginning of 2019, and we will not start any new strategy or any new actions in the middle of 2019, since that would not be fair to the future supervisor that might come in the beginning of December. Once it happened that I'm here in this position, we are right now preparing the strategy for the Data Protection Authority. But finishing this previous mandate meant also that we wanted to conclude the supervision activities that we did. And at the beginning of the year, we have started several big actions that I wanted to have the conclusion by the end of the year.
Okay. So this conference has been focused on AI. Facial recognition is perhaps one of the most kind of widespread use cases of that. The Commission, in a leaked document, said that it's floating the idea of a ban in public spaces. What's your view of that? Is a ban a good idea?
Let's start from the fact that we don't know what the document was leaked. That's probably not the document which is at the moment on the table in the Commission. I heard some rumors that this is the document which was discussed more than a month ago. So this is not exactly what is at the moment the leading part of the discussion on that. Secondly, what has been said by the President of the European Commission was that there will be the plan on how to deal with artificial intelligence, while in my opinion the facial recognition is a slightly different thing, that's a slightly different part of the story. Of course, we can discuss, we should discuss about the possible regulation of the facial recognition, but we have to remember that while there is an overlap between artificial intelligence, whatever this word means, whatever this notion means, the facial recognition, okay, I killed it? No. Okay. Facial recognition is the group of the techniques that are not necessarily connected with artificial intelligence. Well, the typical use of that you can see at the moment, so getting through the passport control in the airport, is just a comparison between the template which is in the system and the actual pictures of the person. So there was no artificial intelligence in any sense that is involved in it. But of course, there might be some things that we have to discuss about as far as facial recognition is concerned. I have the problem with facial recognition because, in my opinion, that is the change, especially if we use it in the public places, the change that we cannot even assess the results of. Let me just go to two examples. Well, the first example would be connected with what's going on right now in Hong Kong and the use of the facial recognitions, possible use of the facial recognition there. And this slogan that appeared there, "Be like water, be water." It's, of course, citation from Bruce Lee, but in a slightly different situation. So be anonymous, start to be invisible for the others, or at least not recognizable from the others. In my country of origin, there was a long discussion about the use of the recordings and the possibility of mask the faces during the demonstrations. That was as an action against hooligans in the stadiums. But actually, it starts to be also the problem of the protests which are going on, not only in the countries which have the problems with general problems with the democracy, but also in some of the European Union countries, where the people are recognized during the demonstration and they have the problems after they were taking part in it. So I would be very delicate. The second use case, which my friend had a contact with recently, was in China, where she was not allowed to exit the lift, the elevator in the hotel at the floor which she was not associated with, because the camera has recognized the face and has recognized that this person is not connected with this floor. So this way of assessing, which is often hidden, seems to be strange for us and seems to change our position actually in the normal life. The people who had the contact with China, who are taking part in the lectures in China, say that while 6-7 years ago that was a very nice, challenging place to have the conversation with the students and the scientists, because you were getting a lot of questions. Some of them were strange, some of them were even offensive, but it was an interesting challenge to go with the lecture to China. While now, recently, in the last months, it changed completely. There are no questions. There is no discussion. And most probably, the reason for that is the fact that there are the cameras around. There is at least a suspicion that there is a facial recognition system in it. There is a suspicion that it might compare it with the information about the people and record the assessment of data. And the chilling effect is incredible. And not the chilling effect because they know what's going on with it, but simply the existence of this technology around is creating. So I don't know if this is the right way to do it, to ban temporary, but definitely the discussion about the spheres where the facial recognition might be allowed should be a part of the discussion right now.
Thanks. I'm having to jump around a bit with topics because time is quite limited. But The incoming Commission has made digital sovereignty the kind of cornerstone of its mandate. Thierry Breton, the Internal Markets Commissioner, has said various times that he wants, European data to kind of benefit Europe. All of this sounds, vaguely protectionist, and I wonder to what extent data protection authorities and the EDPS will be kind of what role they might play in this kind of environment.
Well, I don't know the official strategy in this field of the Commission. It probably will be revealed soon. We start to talk more and more about the digital sovereignty. I understand it as the possibility to make choices. So I may say that all the situations where we cannot make choices, because we don't know what will happen with the data that we are processing, and when we have to believe in the things which were just declared to us, might be also against that. So I would not take it geographically, but the situation where the European Union institution, those whom I supervise, cannot change the software they use, which was so-called only a vendor's lock syndrome, is actually also the part of the sovereignty discussion. Because can we really say that the state, the European Union institution, or the national institutions that are vendor-locked by the big players and they are not able to get into the normal negotiation, normal contract deals with the market, does it mean that they are still sovereign? I would have the problems with. Of course, we are often asked does it mean that we want to keep the data in the European sphere? I would say in the sphere that Europe recognizes as the secure zone, which is not only European Union and European Economic Area countries, but also those to whom we understand and we have assigned the tools that were given us by the directive from 1995 and that are given us by the GDPR. So in this sense, I would not say that this kind of localization is limited to the borders of the European Union, but it's limited to the borders of the entities. With BCR, you know better than me that it might be virtual entity that we can believe in, that we can trust.
Mm-hmm. Actually, in an interview with me, when you first started, you said that you had some preference for data processing, perhaps data storage, to stay within Europe.
Yeah, well, actually, that's what's written. I supplemented it with the same information about the tools that we use to recognize the other parts of the world as being in the same zone as we are. Yeah? So that's what the adequacy is for. But this is also why the tools like BCR have been created. And the fact that GDPR has said the binding corporate rules are the part of the order that we create, or rather that we recognize, because BCRs were created before, and it has been taken into the statutory law, says that that was the idea of the legislators. I never heard about the idea of removing that. But if you ask me if I want to have the data of the Europeans at the place where we can enforce also the European principles, yes, I do have a big preference to that, not only the delicate one.
Okay. Moving on, so the part of this whole digital sovereignty pitch from the new Commission, I think, involves perhaps growing European companies, but also perhaps coming down hard on foreign companies. Margaret Vestager, the digital Tsar of the European Union, has opened several probes into how the big tech companies are handling data. How do you view the interplay between competition and data protection there? Do you see the competition authorities kind of moving in on the data protection patch there, or are you happy for them to kind of do your job, so to say?
On one hand, I'm happy that the problem of processing the data stopped to be only the idea of the privacy protectionists or the privacy data protection authorities to say about the regulatory field, and it came to the discussion also among the other part of the regulators. So, as you know, the European Data Protection Supervisor have been always involved in facilitation the discussion between them. From 2013, we were organizing the line of the meetings, first as the conferences, later on as digital clearinghouse, that allowed the data protection authorities to talk with the consumer protection authorities and competition authorities. So I'm fully in favor of having the dialogue like that, especially that I know that many companies have very fair objections to the fact that there are more and more authorities asking them for the same data and having the same or very similar investigations. So this cooperation should be definitely strengthened. Although at the same time we have to remember that the goal to be achieved by the competition authorities is slightly different than the one which is achieved by the data protection authorities. While data protection authorities are dealing with the fundamental rights, the real aim, the real purpose of having the competition law is to have the fair market. And the fair market is something that you try to influence, you try to regulate in order to make it working, but it's not as strict approach as the one from the data protection authorities that are dealing with fundamental rights on their side. On one hand, we might meet the pushback from the data protection authorities that would say, oh, we are the ones who think about something more important, which are the fundamental rights, while you, competition authorities, deal only with the free flow of work and business. While on the other hand, we also sometimes hear the pushback from the competition authorities who said, we have created very efficient tools, and you want to steal our toys and use them for the other purpose. And both of these approaches are wrong, in my opinion. That should be supplementary, that should be going one with another for the good of the market and for the good of the human rights at the same time. So we should fight with these radical positions and facilitate the discussion. Without the discussion, it will not change. But of course, if you ask me, does it mean that we should merge the authorities? I would say that I don't expect the discussion like that in the next few years.
So not in the next few years, but when then?
Well, I can think in the perspective of these 5 years that are given as the mandate for us. The rest is rather the discussion about the futuristic solutions. At the moment, I would like the system that we created in the GDPR and the directive for the law enforcement authorities to be fully established and fully implemented, and trying to assess how we can change it when we will be able to assess what really happened last few years.
Okay, so turning to just the data protection authorities, perhaps we journalists are impatient, but we're waiting for the fines. Where are they?
Well, if you ask the European Data Protection Supervisor for that, I hope I will never have to issue any fine and any financial sanction against any EU institution, body and agency, because if I do so, and remember that that's an ultimate tool in the regulation for the EU institutions, then it means that they don't follow our recommendations. And I like the fact that they generally follow, and they always follow. So I hope it will never change. But of course, you don't ask me about the EU institutions, I guess, that much. And here, of course, I'm stepping to the very, very difficult ground, because I'm starting to assess the work of the other data protection authorities and the problems that they meet, especially in the process of one-stop shop, which the EDPS is not the participant of. So we are not in the typical one-stop shop system, and I can only echo the things that you probably heard from the data protection authorities about the problems that they meet, not that much connected with the resources, not that much connected with the number of people in the office, but connected rather with the differences between the administrative laws in different countries and the need of alignment of that without having all European procedure for it. But I think the most important, and that's something that I would like you to keep in mind, is the fact that each and every data protection authority is absolutely sure that whenever they will issue a fine, it will be scrutinized and it will be under judicial control. And being under judicial control means, the judicial review means that you try to avoid, you must avoid all possible mistakes, all possible accusations that you are not doing your work fair towards those who are the parties of the proceeding. Because one of the most ridiculous and absurd and I would say damaging things that might happen is when you have a good case, you go through this case and you issue the fine that should really be imposed, but then in the judicial review, you will find that you made the procedural mistake, which is failing down the whole procedure. The first 3 cases lost this way by the Data Protection Authority are killing any kind of respect towards the Data Protection Authority. So the more complicated the case is, the more careful is the approach from the Data Protection Authorities. Of course, the fines have to come, the sanctions have to come, but I don't assess GDPR on the number of fines and on the amount of the money that were earned by the budgets of the European Union countries because of this work. Of course, we can add to that the bigger the company is, the less important is the money it paid. That probably the ban for the proceeding is the more important tool that, by the way, was already in the toolbox of the data protection authorities. That's why also we, as European Data Protection Supervisor, started to be a little bit more brave in issuing bans. We already issued 2 bans against the EU institutions, banning the proceedings, proceedings with the data that were in the agencies.
So you're saying it's less about the fines and more about the other tools like banning processing orders. Can we expect more of those then?
I would not say that this is less about fines, but fines and all kinds of these sanctions, these are the tools which are in the toolbox. And the question, is the screwdriver more important than the hammer, is not a good question. Yeah? We shouldn't start from thinking if somebody did something wrong or if there was any error, we have to start to find and then to think how to deal with the case. No. It should be at the same time. We should first of all remove the possible harms. We have to ensure ourselves that it will not happen anymore. And the fine is important, but not the best tool. That's something which looks nice on the headlines of the newspaper.
Okay, I'm being told to wrap up, so just one more question. We're days away from Brexit. There are 2 aspects here which are interesting for this audience: adequacy and the role of the ICO. What is your view of both? About adequacy, there are some things which we are missing at the moment to know how the adequacy, the decision process will look like. And I think that the biggest gap that we have at the moment is that we still don't know how the onward transfer will look like from the UK to the other destinations. Yeah? Because once again, the mistake that we would do is to send the data to the country which is just the short stop for the data, which is then spread anywhere to the world. So as long as we will not have the clear view on what will be the future policy of the UK for their adequacy with the other, or adequacy of the other territories with the UK, it's hard to say how difficult will be the process. I also hope that we will have a little bit more time for that than by the end of the year. Will the UK be able to skip the queue, as it were? I don't know, that's a political decision, but definitely there is a queue because there are the countries that have to have their adequacy decision reviewed by the Commission, and that's something that the Commission has already started, and sometimes that might be the easy subject, sometimes there might be very complicated. So now that there is a question, should we say to Switzerland, for example, you have to wait in the queue because UK is more important than Switzerland? I'm not sure. This is the political decision. That's something that you shouldn't ask the Data Protection Authority about. And just one last question, the ICO. The ICO is one of the biggest assets that UK has.
They have a strong, very experienced data protection authority, which serves as the example for many other data protection authorities in the practical solutions. I'm not talking about the big politics, I'm not talking about dealing with the big players, but having the real enforcement powers and having the real investigation teams, doing the things like sandboxes in the right way, and having wonderful program for charities, for example, how to teach charities the data protection. These are the things that I was copying when I was in the National Data Protection Authority, and I know that the others do. So they are one of the assets of the UK, and I hope we will be able to use this asset in the future.
So would you like them to be an observer member of the EDPB?
Once again, I don't believe that there is a possibility for membership for obvious reasons, and the observership will be probably, once again, the political decision between the UK and the EU in any kind of decision that will be taken. But of course, it has to be taken on the higher level than the currently existing legal ground. So you then ask me, will they have a treaty on that? I don't know.
Thank you, Wojciech.
Thank you very much.